is, in spite of being notified that your lordship is rising at 1 o'clock, my lord, under compelling situations, a very urgent matter, tomorrow my showroom, the scooter showroom is being demolished at 10:30. And in this situation, my lord, if the lordship's time permits, because it was filed on 27, most probably due to something on the registry side, it was not listed. So if it can be taken up, my lord, I'm obliged, highly obliged to you.
Lordship, I would like to make a mention of from item number 17 to 25. This is a series matter where my learned senior friend is also there. In these cases, in most of the cases, we filed a leave application. In 3, we could not file it the other day because the council was not available to receive the copy. So may I pray that those IS may be brought to record now.
In my case, there are 3-4 matters which were in the last occasion, the lordship wanted to hear me as the leading cases. There are batch matters. And I am told that we have not been served with a copy of the application. What is the application about and what is the contents and prayers, I am not aware. So if that is argued, at least tomorrow, on Monday, I will go through it and address you, because otherwise the cases are fixed on 9 for final disposal.
I would like to have it.
At least one day to go through the petition I will need, because
we'll have it on
9th is already fixed by your lordship for final disposal.
9.
9th.
What do you say, Mr.
No, Lordship, we have, because this has a ramification, it is a constitutional stalemate has taken place. And I have all the judgments of the Supreme Court, all considered. For no reasons, if the electoral roll is ready, no court as well as no other authorities can delay the election process. Lordship. Our notifications was all issued on 28. Notification regarding the final draft. In fact, all these petitions have become infructuous. All these petitions have to challenge
have it on 7?
Lordship, we have very difficult.
7th, we have, both of us have a hearing, election hearing. Either on 6th on Monday or on 9th, your lordship has already passed the judicial order fixing on 9th for disposal.
In fact, Lordship, maybe please take up the matter when it reaches
Today.
But I
Fifth time permits here.
I have
Yeah,
not,
5th time permits. I am sitting here, Lordship. If it is,
So, but
I have not got any.
there are other cases. That's why all the IAs were filed on
why don't we fix all these matters on a
Lordship.
particular day?
That is not the issue, Lordship. The issue is that every day, every moment, there is a constitutional violation.
No, but then
we'll
have to examine the matter also.
So far as 4 cases are concerned, Lordship may delay it for further day. But in all other cases, they have received the copies.
The leading cases, your lordship,
Leading cases, non-leading cases is not the issue, Lordship.
that was what came from your lordship.
Pathak had argued some matter.
Definitely, Lordship.
That matter is not listed
In
today.
his matter, we have
Those have also been
in his
shown.
matter also we have served. He has a copy. The same copy has been filed in all cases.
We have none of us have received.
No, it was served.
Served
It
on
was
whom?
served.
Served on I don't know whom. But my instruction is that
That
none of them have received these copies. At least we must know the contents of it.
or
must know
Lordship, when the matter takes place,
Let
Lordship.
it be
Lordship
taken on Monday. I will come prepared after hearing.
I do not have any objection to that. My submission is that there is a blanket order for stalling the process. Blanket order. Wherever their Gaon Panchayat is involved, that we can stop. But in other cases, Lordship will clarify that.
It will have a harassing ramification.
No, it is a no.
Why don't we have it on Monday?
Lordship,
Yes.
let it be taken up today, Lordship. If Lordship feels that it has to be taken up on Monday,
Let the matter be called
yes.
up.
In fact, I cancel all my engagement for this matter only.
Whatever
The
your
state government is.
applications are there, may be called for.
In fact, in all other cases, the records are already there.
All right.
The same application, because the councils were not available on those days on 26 and 27. So we
It
have
begins
to
from item number 17.
17.
17 is my item. But I have not the copy.
17 to
Let
26.
the matter be called up,
Yes.
because you are going to be here anyway for that.
I will be here. I will be here, my lord.
My lord, I
Highly
have got
obliged.
neither the copy of the affidavit there.
Let the matter be called up, we'll see what happens. Yes.
But on lead petition party instrument closure of declaring mallet was filed on 30th of December mallet. Well, respect of judicial water mallet, they have issued some prohibited water mallet. So matter is urgent mallet, only Monday mallet.
You want the matter to be listed,
Right.
fresh matter.
Monday Monday.
Let us see, give it, the courtmaster will verify if there's any defect and then we'll pass it.
Wait, please, my lord. I beg to mention listing of a fresh motion, my lord. There's some urgency. I would have prayed for today, my lord, but my lord, I know because of paucity of time, cannot be. Well, can it come up on Monday, my lord? What had happened, my lord? The
You give
caster-
it to him, subject to clearance of defects.
Yes, definitely, my lord.
Malar, the one pending matter, Malar, khas lane has become, Malar, patta lane has become khas lane. Your lordship already disposed of similar matter.
Next week, someday.
Yes.
Yes.
Wait, please. I tried for listing admission matter on Monday, my lord. On Monday, my lord.
Why?
Because, my lord, matter relating to demarcation and partition, my lord, and the partition order already passed by the circle officer, my lord. But some process yet to be completed. On Monday, my lord.
Admission matter.
Yes, my lord.
Let us have it on 21st January.
My lord. Last posted on 2nd of December, my lord, and
We have it
directed
on
to the
21st. All the dates are fixed, all the dates are filled up.
my lord. Okay.
By declaration item number 5, my lord. This matter, he is out of station, my lord. Ask for the matter for the day, my lord.
Next week, item 5,
Obliged.
request
I
of
beg to
counsel,
mention,
hearing of the,
I beg to mention item number 11, but
yes,
only pass over for the day.
item 11 also. At the request of counsel is the petition.
Obliged.
Yes.
Lordship, in item 34, I file an affidavit that may be called for.
Item 34,
Lordship.
item 34,
Yes.
call for an affidavit.
May I please, I beg to mention for item number 7, Lordship. Kindly pass over the matter for the.
Item 7, passed over.
Obliged.
Please, your lordship, with regard to item number 8, I'd like to make a mention, lordship, for adjournment.
Huh?
For adjournment, your lordship.
There's an interim order.
Yes, your lordship. My senior is having some personal.
You take consent of the counsel for the respondents. Who's there?
The railways and
No, you take consent. You are enjoying a stay order, then you should have made alternative arrangements. You get your consent from the other side.
May I please your lordship, I beg to mention item number 13 of today's daily list, may be adjourned for 2 weeks, your lordship.
Item 13.
13.
At the request of the counsel for petitioner.
Yes, your lordship.
Then
Please,
adjourn for 2 weeks. Yes.
upright.
Wait, please. Section 11 application, lordship, arbitration agreement at page 40, lordship. In a partnership deed, lordship.
4-0.
40.
The counsel for the parties issue notice, return of 4 weeks. Steps on respondents. How many respondents?
Only one respondent. One respondent.
By registered post ID. Within 2 weeks from today. Custody is also permitted.
Public.
May I please, Lordship. Section 11, petition matter for appointment of arbitrator matter. Arbitration clause
where
is
is the agreement?
20, my lord.
Page number?
20. Clause number 2 is the arbitration clause, my lord. Dispute between the partners, my lord.
Heard learned counsel for the petitioner. Issue notice, return of 4 weeks. Steps on respondent number
Sole respondent, my lord.
on the sole respondent by registered post ID within 1 week from today.
Deeply obliged, my lord. My lord, may come
Yes.
to page 10, my lord.
Page 10.
Yes, my lord, the order that
Where
has
is
not
the
been-
operating part?
operating part will lordship to find the lordship.
Where is the direction?
Page 12, my lord. Page 12, third paragraph. In view of the nature of the dispute, this court is also of the opinion that the matter should be relegated to the authorities to the first demarcate the land in question between the petitioner and the respondent number 4. And in the event it is found that the proposed construction is over, the petitioner shall be allowed to carry out construction of the boundary wall as per the exact terms. However, in the event it is found that if by the authorities that the proposed construction is over, the land claimed by the respondent number 4, they may refuse such NOC and the parties should be relegated to civil court. The remarcation be made in presence of both the petitioner and the respondent number 4. The petitioner and the respondent number 4 are directed to appear before the circle officer, Tinsukia Revenue Circle, on 21/10 for 24 miler, on which date the circle officer may fix a date intimating both the parties to remain present for the purpose of demarcation. Such demarcation be made within 3 weeks from the date of appearance of the parties before the circle officer.
All right, heard.
Now, what is
Learned counsel for the petitioner. Agree by the willful disobedience, alleging willful disobedience and non-compliance of the direction contained in the order dated 23/09/2024, passed in WPC 1030/2021. This contempt petition is filed. Issue notice, another 3 weeks, steps on the respondent, sole respondent by registered post AD within 2 weeks from placed after the returnable date.
declarable?
Matter less to non-issuance of so-called notice, covered matter by lordship order, my lord. I've given the order, my lord.
Well, we are praying for 7 this time, to instructions.
All right. Heard learned counsel for the parties. Petitioner is agreed by the order dated 3012/2023, passed by the respondent. Which respondent?
Phone number 3, my lord.
Respondent 3, raising a demand of rupees 5,99,528 as a demand for GST required to be paid by the petitioner. Petitioner is agreed that no show cause notice prior to issuance of the impugned order was served the petitioner. The counsel for the petitioner submits that coordinate benches have passed orders which he relies upon in support of his contention. Mr.
H. Burwa, my lord.
H. Burwala, counsel appearing for the respondent.
All the respondent, my lord.
All the respondents submits that he be permitted to complete his instructions.
My lord.
He prays for a week's time. Now, 1 week means it goes beyond the holidays. We'll fix it on 10.
My lord.
Prays for some time. Let the matter be listed again on 10. Meanwhile, the petitioner will serve sufficient extra copies to the respondent during the course of the day,
My lord.
complete his instructions.
Declarable.
Item 6.
Who's for the petitioner? None appears. The petitioner, the matter is called. MD Bora appears for
Transport Department.
the transport department. This is the matter next week.
Publishment.
Item 8.
Yes.
Lordship, can the matter be taken up on Monday, Lord? On Monday, Lordship.
Yes.
Otherwise, also, I have received instruction from there
as they also motion when they have mentioned the matter without informing us, they have pursued the matter. Otherwise, Lordship, the all notice was issued and
We,
all
we'll have it on, seven.
all procedures followed, Lordship.
We'll have it
Section
on
4,
7.
Section 5 notice is given, Lordship, on 2011. District judges.
All right, we'll have it on 7.
Lordship.
At the request of counsel for the petitioner, let the matter be listed again on 7.
Lordship, interim may be continued.
The interim order passed earlier will continue till the next day.
Like,
7th of January. On appears for the petitioner on call. List the matter next week.
May I please, your lordship?
Yeah.
This is with regard to that land acquisition for the bridge from Amingao to Panbazar, that connecting bridge, lordship. Land of the petitioner have been acquired, but meanwhile, lordship, there are two DUGs, DUG number 366 and DUG number 519. Meanwhile, he has received for 519 after he has given the representation. Only with regard to 366, he has yet to receive compensation, lordship.
It should notice at this stage. You should notice at this stage.
Yes, lordship.
Mr. Nayak, anything to submit?
No.
Heard clerk counsel for petitioner. The petitioner is aggrieved by non-receipt of compensation for land acquired against spot. It is submitted that land covered by which DUG numbers?
DUG number 366 and DUG number 519. Two DUG.
Where have you stated paragraph?
Paragraph, lordship, I have stated in paragraph 7, lordship. Both the DUGs are mentioned, but one I have received. 519 I have received.
DUG number 366 as well as DUG number 519. Both belonging to the writ petition. It is submitted that compensation for land acquired under DUG number 519 will receive. However, the compensation in respect of land covered by DUG number 366 has not yet been received. In spite of representations filed before the competent authority, the same has not yet been released. Being agreed, the presented petition has been filed. Issue notice, return for 4 weeks. Mr. P. Nayak, PS4.
1 and 3.
1
and 3.
1 and 3. MSG Hazarika for respondent number 2. Mr. S. Purua for
4 and 5.
4 and 5. Who's for finance?
Finance 3, Lord.
Or 3 you can appeal.
Of course.
Since the respondents are represented, notices are waived. However, extra copies be furnished within a period of 1 week from today. List after the return period. Respondents may complete their instructions and find necessary affidavit.
Please, your lordship, that delimitation matter, my lord, can it be taken up with series 18 to 27, my lord?
Yes.
Same issue.
All right.
I think 14.
In this case, my lord, pursuant to an order of this honorable court, my lord, the settlement of land was approved by the BTC, my lord. And subsequently, my lord, the circle officer unilaterally erases the value, my lord, as my lord per acre 60 lakh, my lord. And I was asked to deposit as premium of the settlement, my lord. But when the proposal was submitted, my lord, the value of the land was assessed as the 2 lakh rupees per acre. If the lordship, the order of this honorable court, my lord, that is page, my lord, at 31 and except 5, my lord. This honorable court has taken note, my lord, 36 relevant, my lord, paragraph 9, my lord. Page 36. Paragraph 9. No? The matter was pending since 2018. Taking note of this, my lord. Then subsequently, my lord, the allotment is at page, my lord, 37, my lord. Approval of the recommendation of the SLDC, my lord, subdivisional level.
There is already an order. There is an order passed by the court.
Yes, my lord.
Then what happened after that?
Then, my lord, 37, my lord. Approval for settlement, my lord. And
Ah.
in this order, my lord, the with reference to the subject, I am directed to say that the Borderline Territorial Council is pleased to approve the proposal for settlement of land to the following beneficiaries submitted by you by letter so, which was duly approved by the SDLAC Hergaon subdivision in its meeting held on so at Kolaigaon Circle. My lord, this is my husband, my lord. The land record may be corrected after realization of the premiums, my lord, and deposit of the premium so my lord. The premium has been already fixed by the proposal, my lord, and considering all the aspect, my lord, my proposal was approved, my lord, by the subdivisional level land advisory board, my lord. Then approval was approved by the BDC, my lord, and subsequently, my lord, the circle officer, my lord, there is page 38. And vernacular 39, my lord. Again, reassess the value, my lord, at 60 lakh per week, my lord.
Yes.
Instruction necessary, my lord.
Third level counsel for the so third Musari H Musari
R.K. Musar.
R.K. Musari appearing for all the respondents.
No. 2, 4, and 5.
2, 4, and 5. MS G. Hazarika for respondent 1, Mr. S. Borua for respondent 3.
Yes.
The counsel appearing for representing the PTAD will obtain required instructions. Let the matter be listed again on 2020 in order to enable the learned counsel for the respondents to complete his instructions. Sufficient extra copies be furnished during the within 2 working days from today.
Obligement. Item 15 is the same, my lord.
Item 15 also same.
Item 16.
Obligement.
Matter relates to cancellation of GST registration, my lord. But the order is at page, my lord, 28. Now, my lord, in this order, my lord, no reason is assigned, my lord. Why it has been cancelled, my lord?
Cancelled because you did not file your return. Simple as that.
It was
What
cancelled
reasons
to
are
file
there?
24, it was cancelled. I have filed all my returns because of my ill health, my lord, could not file the
Any
returns.
appeal filed?
My appeal time was over, my lord. But
What
it was
is
recently
done?
cancelled.
What is to be done? Similar orders.
Lordship may direct him to file application of restoration before the concerned authority within a period of 1 month. They will consider it for that.
No, consideration means consider for registration. He will see, he will pay all his dues, whatever is there. And thereafter,
Lordship, page 65 may consider.
65. Yes.
A similar direction may be.
He has to make all full payments.
Lots.
I have done, my lord.
That provided in the rules.
Right. Disposed of.
Deeply obliged,
General
my lord.
counsel for the parties. Yeah, covered better.
Deeply obliged.
A serious matter, Lordship. It is a part of the petition.
Yes.
So,
The problem is that we have not received the copy, my.
yes, that I'll make my submission, then Lordship will
But you
definitely.
have to give them the copies before you make your submission.
No, Lordship, the thing is that I have the record. We contacted their counsel. Their counsel gave the number of their advocate's clerk. We submitted to that advocate clerks on 30th December. It is not that we are not giving. In 3 cases we have given. Those are also listed. Those can always be heard. They cannot deny that they are not receiving copy. And
No, we are now taking up item number 17. Sorry.
7 is a fresh case. It's a fresh case.
17 is the government eye.
Huh?
It is their IA for vacating of the stay orders passed in the other batch series.
In which matter?
17 is a fresh case. It's a new case.
IA has been filed.
Yes.
18 from 18 onwards, it is the petition.
Now, so far as 18 is concerned, what we are seeking, Lordship? May I just place 2-3 pages?
Yes.
If Lordship is pleased to take up that interim order, which Lordship will find, if Lordship is pleased to take up 5706. Read petition
5706.
item 23. Why there is a hurry, Lordship, that also I'll explain.
Yes.
17, Lordship will kindly come to page 33. The order of 17 December. Heard so and so. Second paragraph. Order dated 29/11/2024 reflects that the matter is deferred until today.
Wait. You are referring to
In the IA.
5706.
5706, the IA is 4091.
4091 IA.
IA.
In item 18, it is not there.
In fact, same IA has been filed in all cases.
So we have item 18 before us. The IA in item 18.
Lordship. Then same, it will be, everything is same.
Then page number 33.
33. In the first paragraph, the council's names are there. Second paragraph, order dated 29th November. Have Lordship got it? That the matter was deferred until today at the request of learned counsel for the state. Additionally, the assurance was given by the additional advocate general that no notification would be published during this period was duly noted and incorporated in the order. Today, it is submitted that the state has filed their counter affidavit during the course of the day. They have received all these affidavits. There can be no denial. Under such circumstances, the learned counsel for the petitioners prays for some time to complete his instructions in the matter and submits that the matter be listed in the month of January on a date convenient to the court. He, however, submits that the court may consider grant of interim protection to the petitioners. Lordship will kindly mark this. Consider grant of interim protection to the petitioners in respect of the proposed election to be undertaken by the respondent. The learned counsel for the respondents, namely Kumar and Dubey, learned counsel appearing for the election commission, submits that the notification for election will be issued by the state election commission. R. Dubey, learned counsel for the election commission, submits that the process is underway and the electoral rolls are presently being finalized, and once the process over the election notification will be issued. Under such circumstances, this court is of the view that the matter requires urgent hearing and therefore listed on 9/1/2025. Till the next date fixed, the respondent shall not issue any notification without leave of the court, as this matter is pending disposal before this honorable court. Here, the subsequent development is on 28th of December, the final electoral roll has been issued in all the constituencies of the state. So, all their cases have become infructuous. They have to challenge the final notification, number one. Number two, what they are saying that protection of the petitioner, the second line from top. We have, if Lordship is pleased to take the election commission's vacating petition, last page.
That is in item number 23, Lord, I number 4092.
Last page.
You have filed only one.
Yes.
The record, one document I would like to place. One paragraph from this affidavit and one paragraph from the press release.
Yes, page number?
Last page, page 60.
Yeah.
Total number of districts 27.
Hmm.
Have lordship got it? Total number of Jilla Parishad constituent 397. Total number of Anchalik Panchayat 181. Total number of Gram Panchayat 2192. Total number of wards so and so, so and so. So far as the writ petitions are concerned, it will be not more than 20 number of Gram Panchayats. Why the whole state should suffer? The order which Lordship was pleased to pass on, Lordship may clarify that the writ petitioner's constituency may be protected till Monday. And why we want Lordship urgency, paragraph 10, page 12. That is the main point, Lordship, of that same IA, the Election Commission's vacating petition. Why every day is very crucial. Paragraph 10, that the State Election Commission has already issued necessary guidelines, circulars, and instructions not only for preparing electoral roll, but for conduct of the election as well. The Commission has also developed software for randomization of polling personnel, randomization of total ballot box, and dealing with claims and objections online electoral roll management system. The Commission has traveled all over the state and conducted review meetings with Deputy Commissioners, keeping in view the timing of conducting the election during the month of January 25 till early February 2025. This is the present time. It is respectfully brought to the notice of the Honorable Court that a period of 30 to 40 days is required for completion of the election process in 2 phases, from issuing the notification for election to declaration of the results. The said window of 35 to 40 days for election is only available between first week of January 2025 and second week of February 2025, as high school and higher secondary school examinations are scheduled from 13 February to 17 March and 15 February to 3rd March, respectively. The exams are to be followed by budget session of assembly, which should commence 3rd, 4th week of February and is likely to continue up to the last week of March. It is humbly stated that
we are not we are conscious of the difficulties faced by the state. So
now we are already delayed by.
We are also anxious to hear and complete the matter.
Absolutely, Lordship. Now that
as on date, the respondent, I mean the opposite parties, they say some of them, I don't know whether.
That is why Lordship may clarify in respect of their constituencies, we will hold on the election notification.
These orders, this interim order that you have pointed out.
Yes.
Where
No,
is that page number in this IA?
If Lordship clarifies, then definitely Lordship.
42, my lord. 42. 42.
In view of, no, this is not 42. 42.
Starts at 42, operative part at page 58, not any lot.
Page 59. 59. Till the next date, the respondent shall not issue any notification.
This order was passed in which of the matters?
In all the cases. In the series of cases. If
the series
first
which
paragraph
is listed today.
Yes, Lordship, page 58, all the cases are also mentioned, case numbers. So if Lordship clarifies that in respect of the writ petitioner's constituency, will not issue notification because they are agreed by their electoral roll.
I think that's a very reasonable prayer because this is not a public interest litigation.
Apparently appears to be, but actually it is not like that. Let me tell you.
We'll just hear what do you have to say here.
My lord, the issue involved, we deliberated from all along. After that, issue involved is here the delimitation process that was sought to be carried out was in violation of Article 243C. And Article 243C of the Constitution, first part says that states shall make laws for establishment.
No, we are not into the merits. We are asking you, in any view of the matter, on a fair perusal of this order, this order was passed in respect of certain writ petitions.
My lord.
Now the prayer made is that this order should be restricted to operating only in respect of those writ petitions.
But the problem is the ratio has to be maintained all over the state in one ratio. That will be the main problem.
No.
Suppose today
Other people have not come, we can't wait for
The-
them to come to the court.
Recently, the apex court, my lord, is aware of that. If there is an illegality which has been adjudicated by any court of your lordship or the apex court, which will ultimately will be a judgment in rem affecting all,
We will look into that aspect. Supposing,
my lord,
supposing we arrive at a finding, we do not accept your contentions and we have to reject it.
Yes.
Then the whole process gets derailed.
Because
This
if the
process
election
which
is
gets started, in the event we allow we accept your submissions either in part or in total, some directions may be issued, may not be issued.
But
now, technically speaking,
my lord,
this order was passed on the premise of certain writ petitions. So obviously, this order has to be operating only in respect of those writ petitions.
I understand, my lord. But the issue that is being raised in all these batch of writ petition is an issue which, if determined this way or that way, will be a judgment in rem that, in all fairness, that may be judgment in rem affecting the entire state of Assam. Because if an election is now allowed to be held only on the ground that some petitioners are not before your lordship, some panchayats, and election is held there, that tomorrow there will be some petitioners, suppose it is allowed, a ratio that is applicable to the state. If I trouble your lordship with the language of the Article 243C.
See,
only
ordinarily, as the law stood earlier,
my lord,
is that you wait for the elections to be over and then come and challenge whatever irregularities
Yes, 2
are
months
there.
back it has
But
been changed. Now it has been changed back.
It has gone through some changes. But the essence of the principle is that this is not something that your challenge to the process will become infructuous merely because the election is being held.
My lord, I bow my head down, my lord. 243C, my lord. The lordship will carry. 243C has two parts. 243C first says that, I'm sorry. 243C was introduced from Article 40, which was originally a directive principle of the state policy.
Yes.
Later was brought in as a part 9.
Yes.
243C says it is the prerogative of the state government. It is the state governments are duty bound to make laws relating to the local self governments. But there is a two proviso. First proviso is regarding the size of the panchayat, provided that ratio between the population of the territorial area of a panchayat of any level, it may be Gaon Panchayat, it may be Anchalik Panchayat, it may be Jila Parishad, and the number of seats in such panchayat to be filled up by election shall be, so far as practicable, be the same throughout the state. Now, our contention was that because of now here, because of this, my lord, Section 6 was introduced to Assam Panchayat Act. Section 6, your lordship, number of seats in a panchayat is fixed at 10. Is 10. Now, in the numerator is 10 fixed. Now, denominator now has to be adjusted. I give you a small example, your lordship. It is like this, my lord. If suppose there is this much of a village, it has 10 seats, 10 number is seats, or numerator is fixed. It has 100 population.
So, Mr. Pathak,
my lord,
we will hear and examine your matters. If you want to revert back, file your objections, whatever you want.
It is already fixed on 9th.
You have to do it, whatever date you want. What we are asking you is, whatever proposition you want to argue, will be restricted to the pleadings available in vis-a-vis the
only
parties
my
before the
humble
court.
submission that only this much maybe that any judgment that will definitely it will have a bearing all over Assam. My anxiety is that
that is subject to a person who comes to the court as an aggrieved party.
But I bow my head down, but their apex court has recently said in that BSF matter that it is not necessary in in such kind of matters where everybody is apparently aggrieved, but only few of them have come, and therefore it will be only limited to the few of them. If it is a judgment in rem, a judgment which will be in a rem, so not necessarily everybody has to be at your
That's
lordship.
what we are saying. So if it is a judgment in rem, whatever we decide, supposing we uphold your contention,
My lord.
if any aggrieved party feels that no, in view of this law, whatever process has
The process will
was
be
undergone,
process
have
will
to
be
be
election tribunal.
scrutinized.
Tribunal cannot decide because after the election is held, the process gets in a different way. Election is held, after that, it will be through an election tribunal that can be challenged. So it is not now the delimitation process, there are different, we are at the beginning stage. After it is held, the process is different. That is only my humble submission, my lord. The lordship will kindly consider.
You are not in a representative capacity for all.
My
Are you
lord.
in a representative capacity?
No, definitely not. I am representing three or four districts.
Then
My learned colleague is also representing another 4 districts. So I am representing district of Kasar.
See,
Hailakandi.
the submission made by the learned advocate general
My lord.
requiring the court to pass a clarificatory order technically is not required because an order passed by any court will be binding between the parties.
Look, may I have the indulgence, my lord? I am only at this stage I am saying, may I have the indulgence at least to know the pleadings made in that application. Till now, I do not know what is written, what is not written. What is ultimately, and later on, it should not so appear that I am aware of the contents of an application on which I am addressing your lordship now.
My lord, I have something.
I'm sorry.
What we want to say is that this is clearly an order passed in a set of writ petitions. This order will bind the parties to the writ petition. He wants a clarification to say that this will not be used as a blanket order to prevent the process or stop the process from proceeding ahead. This, I don't think, is a very unreasonable submission because
I find one.
plain reading appears that this order has the effect of being understood as a blanket order.
Madam, that's true, madam. Now, what is the question? Question is, madam, why this IA? They want, madam, not to delay it further. This is the one they are contention, madam. Now, I take your lawsuit 243E, madam, Constitution, madam. So, 243E, madam.
Yes.
Your lordship, duration of the panchayat. Every panchayat, unless sooner dissolved under any law for the time being in force, shall continue for 5 years from the date appointed for its first meeting and no longer. Then 3, your lordship, kindly see. 3, sir. An election to constitute the panchayat shall be completed before the expiry of the duration specified in clause 1. So term is 5 years. 5 years already gone in last December 2023. Madam. And he says, suppose an application to be completed before the expiry of its duration, specified in clause so and so. So now what is the argument today, madam? After 1 year, you have
this is a constitutional provision, Mr.
Constitutional no.
So therefore,
you fail.
No, maybe
now you are coming, the
now,
case is fixed on 9.
No,
now
because-
today you are
because
coming
they-
said that madam, heaven will fall.
they fail,
Madam,
because they have failed, is all the more reason to expedite the process.
it
And
is because they have taken time, madam. Your lordship kindly see their orders. Your lordship kindly see the orders, madam.
all right, we'll
Madam,
you want to file,
kindly have a madam. Your lordship was whatever.
you want to file any objections here?
Yes, madam.
Definitely. I also will file.
Yes, madam. We have not got. We do not. Only I have heard
Instruction to
from
file.
his mouth that because they are urgency. Now urgency is 1 year back. Panchayat already over. You failed to hold election prior 6 months prior to the expiry. Now coming to only 1 week left. Now we are coming to say that yes, madam, heaven will fall.
What is
An
the
election-
what is the constitutional provision in respect of a situation like this,
Yes.
where before expiry election could not be held? What is the value of that? What is the status of that body?
So it is because Panchayat, the deputy commissioner, it's paid by what they have by a notification. They have stated that the deputy commissioner, he is entrusted with to look after the. So he is looking after. But so far, constitutional matter, it is you failed. Neither court failed, nor we failed, nor anybody else. Now you are coming only 1 week, only 10 days, remain matter 9 days, only 3 days. 5 days or 6 days, matter. Now heaven will fall.
All right, we'll
And
issue,
some other case also filed today itself. Today
We'll-
also we filed
we'll issue
something.
notice here in the IA.
My lord.
You give them.
My instruction,
On Monday,
my instruction is that from all the
they
three cases,
deliberately
they
avoided to
want to
receive
file
the
objections.
No,
After
I am
receipt
trying
of
to
these
say, my
copies,
lord.
they want to file objection.
No,
at
no,
least.
please.
No, not
The IA.
The,
Should I?
That I
the clerk and all. We call
Under order
everybody.
three, under
We call
order three, rule
everybody.
two,
We
clerk
call the
cannot receive.
councils also.
And under order three, rule two, because let me be very clear on this. Order three, rule two of the CPC, which spirit applies now, the amendment, it has, Guwahati High Court rule also has been amended. A clerk is not incorporated in under order three, rule two. Therefore, in the light of that, a requirement that has been laid down by a notification now in the Guwahati High Court rules, that advocates' email ID and the contact number should be given for any service. That was given. Now, a plea is sought to be taken, most probably, although Advocate General, I'm sorry, is not taking, that some clerk received it.
Some advocate received in WhatsApp whole petition.
No, but why don't you send it by email? If the
Yes.
email is available.
That is the
WhatsApp
Guwahati High
number
Court
is also given. In any case, Lordship, today they are getting it.
My lord,
In any
I
case-
was ranked 2 times to give the copy, but I gave the address detail which is near to the High Court, but they did not.
All right.
And not a copy of the
We are
affidavit.
issuing a notice, short notice for you to
With
file
an
your
instruction to serve it in the course of the day, so that
Today
we can
itself
file.
now,
Yes,
for
yes.
going to the boundary of the court, we'll serve them.
No problem, no problem. Even after.
We give you liberty to serve them with soft copies.
Yes, that is what the
Highly
Guwahati
obliged.
High Court rules has provided.
Soft copies are there. Why don't you serve them? As many councils as required. We are,
Because that is the requirement, that's just now, recently it has been amended.
all right.
The council provided the WhatsApp number. That's
PDF, it can be sent.
whatever they have instructed, we have done it.
It can be sent in PDF also.
You are appearing in which IA?
I am appearing in
Number?
all IS,
4089.
in all the cases.
Now, how many IAs have been filed?
I am appearing in one.
4094.
I'm giving the numbers, Lord. That clarification may be given.
Just copy
In
it.
fact, as an abundant caution, I am taking that.
In the
In
course
fact,
of
that
the day,
opinion was
we'll
already
get it
given,
and we'll
but
file our
election commission is little bit skeptical.
Heard.
That's why I'm praying that, Lord.
Heard Mr. Devajit Saikia, Learned Advocate General, appearing for the
Never.
state, assisted by Mr. More additional AG, MS Bora, Standing Council. His IA has been filed seeking vacation, modification, alteration of the interim orders passed on 17/12/2024 in WPC so and so, so and so, so and so, whereby the court directed the respondents, namely the appellants herein, not to issue any notification for the panchayat elections pursuant to completion of the electoral rolls without leave of the court, as the matters are pending disposal before this court. Mr. A.P. Pathak, Learned Senior Counsel, and Mr. H. Chaudhary, H.R.H. Chaudhary, Learned Senior Counsel, representing some of the opposite party writ petitioners, as well as Mr. So-and-so, so-and-so, so-and-so counsel appearing for the petitioners, submit that all the councils have not been served with the copies of the IE, and therefore they are yet to complete their instruction, and therefore are unable to address the court with these matters. So, the learned councils appearing for the opposite parties / writ petitioners also submit that they may be given an opportunity to file their objections if so advised in the meantime. Accordingly, let notice be issued in this IA. Matter be listed on, we'll have it on 9th, 9th of January, on which date the the respondents, the opposite parties slash petitioners may complete their instructions and file necessary objections if so advised. So it is made clear that sufficient copies of the IAs filed before the court by the state as well as by the Election Commission shall be served on the councils, respective councils for the petitioners slash opposite parties during the course of the day. The liberty is granted to the applicants to serve copies through the respective emails. Councils for the petitioners slash opposite parties are permitted to share the emails, registered emails.
It's already there.
It is already the
Permitted.
all the details.
Nowadays, the requirement under the Guwahati High Court rules
All
is
right, then strike.
If necessary, we'll get copy, man, no problem. If we get one copy, we'll do it, man, no problem.
On the clarification.
Place this matter on along with the petitions on so and so.
Obliged to us.
Then with the writ petition, you're right. In so far as, where is this order?
At page
17, 12.
17, 12.
It has been brought to the notice of the court that the order dated 17/12/2024 passed in WPC so and so, so and so, so and so. This you will take it in writ petition 6413.
5706. I'll give the numbers, but in 45.
No, it is available in the order.
In all the cases, it is available. IS.
Order, the page number 60 note, Silabo, writ petitions are there, numbers are there. The order dated 17/12/2024 passed in WPC numbers so and so, so and so, where the respondents have been restrained from issuing any notification without leave of the court, as the matter is pending for disposal before this court, is operative only in respect of the writ petitioners, in which writ petition the order dated 17/12/2024, 2023 was passed.
Highly obliged.
Rest of the matters here,
I couldn't.
we have clarified that it will be binding only on in respect of the writ petitioners.
Notice to.
So ultimately,
We are
election,
issuing notice in the IA. IA is for vacating alteration of the interim order in respect of the interim order passed in the writ petition filed by your clients. But we have made it clear that the interim order which is passed is applicable only to those writ petitions.
but ultimately election notification will be issued, my lord. So
Will not issue to their consequences.
Huh?
No.
No, I'm not saying
No,
to our constituency.
This interim order will be operative against the writ petitioners.
I'm not on that matter. Once it is, it will be issued today or tomorrow, my lord.
Whatever date.
So once notice issued, but there is no use of
Then
issuing
in
notice
that
also,
case,
my
there
lord.
will be nothing will be left to answer
Yes.
to the notice issued by their lordship in their eyes. Because we want to place an objection to their eyes, copies of which I do not know. At that juncture, at least for natural justice, let us be served with a copy, let us file an objection. Your lordship, if your lordship so desires, then may pass the same order. But at least we should be given at least an
It
opportunity.
is a clarification order, Lordship has passed. It
for
is not diluting the
they have
order.
filed an application before your lordship. And we only pray that we should be given that much of a natural justice that we want to go through it and file something, an objection.
As far as the writ petitioners are concerned, you are protected by an interim order.
Oh, my lord, we want to just place on record, in the interest of natural justice, our stand toward their application.
Your rights are protected by virtue of the interim order, which is still operating.
That much is there, my lord.
Right.
There is
And
other
we are
aspects.
giving you, they have filed a vacating petition seeking vacation alteration of the interim order passed. So we are giving you the liberty to file your objections there too.
I understand, my
But this order can't be used as an order for everyone.
They are from Barak Valley,
Whether-
and how can the election of Lakhimpur be affected?
It has to be.
For that also, I want to at least place on record how that Lakhimpur will be affected. Let me be at least for
But
at
you are-
least for
you are not-
interest, because
Lakhimpur is not before you.
any order that is passed, a constant ratio has to be maintained all over Assam.
Highly obliged.
No, that is all right.
No, my lord.
But the question is,
My lord, only thing, once notification issued, election is held. The rest only petition that will be influenced was just like by election, my lord.
Yes.
So many consequences will be,
Oh, no.
my lord, following.
Lordship will bear with only for
Only
3
1
days.
week, yeah, 1 year has gone.
Lordship, the
Only
election
1
will
week.
be in
has
2
gone.
phases.
5 days
Election
were
will be
hard.
in 2 phases.
Only 3 days, my lord. That much.
Phases?
Only your lordship will record my submissions that Mr. Pathak wanted to submit it. Objection after receipt of the copy. That much in all fairness of the proceedings, my lord. I am not requesting anything. In all fairness of the proceedings with folded hands, my lord, I am requesting.
In 3
Mr.
cases, they
Pathak
have
prays
received the copies.
At this juncture,
In these
that
batches-
he may be served with a copy of that application, to which he will like to respond.
Yes, Mr. Advocate.
Till
Lordship,
9 only.
You wait till 9th.
No, Lordship, I fully, my humble submission is that, in fact, a opinion was already given to the election commission that this order is binding only to in respect of the writ petitioner's constituency.
He has given out.
As an abundant caution, which Lordship, it has fallen for Lordship mouth. That is a,
Because
that is the normal meaning,
it is a
normal meaning,
plain reading.
plain
It
reading,
has to
Lordship.
be understood.
In spite of
it's
that
operating.
opinion with election commission, they are still filing this.
Why are you addressing the court on this issue? This is not a public interest litigation. You are not before the court in a representative capacity. How do you project the interest of a Gao Panchayat which is not before the court?
If they have submitted copy, my lord, in respect of that, my lord, it means in my case also they have filed this one, my lord.
We are not
I
going
have
to
right
hold
to
election
answer, my
there
lord.
now.
You are protected by the.
My lord, if they have given opinion to election commission that there is no need of filing this, my lord.
I have one more submission, my lord. We can look at it from 2 sides. Whether I am trying to protect the people who are not before your lords. Number 1. Number 2, whether the order passed in this batch of petitions before your lordship is going to be adversely affected by holding of at least that much of a reasonable opportunity. Only my submission, my lord.
Lordship, what is
No,
their
we
case?
will, Mr. Pathak and Mr. Chaudhary, please understand one thing. You can only address the court on the premises of your pleadings.
Correct.
Your pleadings are pleadings made on reflecting the grievances on behalf of the respective writ petitioners. So whatever orders we pass or whatever arguments you make are on the basis of the grievances raised by those petitioners. Now there are a set of
My instruction,
persons or committees or panchayats who are not before this court.
my instruction is, my lord, that what for exactly we wanted a copy and to address our affidavit.
We will.
No, I will
we
just
will-
make
we
it
will
clear. I
hear
will
you
make
on
it clear.
this.
I will make it clear
Huh.
that how this particular order, if passed, is going to adversely affect the pending cases. That much we have to, at least that much of liberty should be given to us, my lord. Only my submission may be recorded at this stage. Mr. Pathak prays that he may be
We
supplied.
will
with a
add
copy.
one more that
Heaven will not fall on them.
any
My lord,
any election, we will say that the election in respect of these panchayats before the court
my lord,
will not be proceeded with until we decide the matter. There is already an interim order.
There is already, we are not going to do that, touch it.
That is not the question, my lord. Question is, my lord, another aspect, my lord. Once the election notification issued, only this petition of these areas will remain.
Yes.
Others will, so naturally that will consequence will be there, my lord.
No, no, no.
We-
But
General election will be held in
We will
respect
revert
of all
back
others.
to your
my lord.
lordship.
we are asking you repeatedly one question. Please tell us, are you in a representative capacity?
Yes, I am in a representative capacity for the district of Kasar, Hailakandi and Morigaon.
Right.
These three districts.
Karimganj. I am
Apni
here.
Karimganj.
Mangalore, Durham district also.
Dorong, he is for different districts. These three districts, what I am instructed by my learned instructing council, if election is notified today, how that notification is going to adversely affect the merits of the pending cases, that's what at least, that's what we wanted a copy and to revert back. Only that much of submission for all fairness may be recorded, that I wanted a copy and want to submit my objection to it. Till that, within the time stipulated by your lordship already.
My lord,
That much of all fairness of the
Same
proceedings,
here,
that may be recorded that we wanted a copy, but that cannot be
You
given now.
wanted a copy of what?
Of the IA, they are moving now.
I have not
and
opened also today. I have not
Only
relied upon
that
the
much
IA
of
also.
fairness, my lord. That
My
may be
IA was
recorded.
not opened also.
All right, we'll take it up again on Monday.
My
on this
lord.
issue.
That clarification may be
meantime-
there, Lord.
No, that clarification will, let us give them an opportunity.
Lordship, then my submission, I am not touching any of the IAs. Lordship, I will place the Supreme Court judgments on this. They in fact have no case
But
at all.
But they have not received copies.
Any
What can be done about it?
I am withdrawing those. I am withdrawing those.
Then you'll have to file a vacating petition. You have already filed a vacating
Lordship,
petition.
the ball is
You
very
see-
clear.
See, the problem
No,
is
Lordship.
that, you see, the problem is.
No, Lordship, every day is crucial. Every day is crucial for us.
crucial, but on the day when
No.
when we passed an order,
What-
we was
Now Lordship has already passed an order. That order is absolutely on all legal principle. It is correct order. When a petition, if it is a public interest litigation, this matter should have gone to court number 1.
yes, correctly. But the problem is.
There is no
or
problem
what-
at all,
the
Lordship, in my
problem
humble
is that
submission.
you have filed a vacating petition,
I have filed a vacating.
and for whatever reason, they have raised an objection
Lordship,
that copies
in
are not served.
in threes, they have received the copies. It is not that they have not received the copies.
But then they're also entitled to be
Yes,
given an
Lordship.
opportunity.
They got it on 29th. And during the vacation, we tried our best to convince the registry to get it listed today. We are violating all constitutional norms.
Wait until Monday.
Lordship, that clarification,
What until Monday? What is your difficulty there? Today
our
is Friday.
difficulties every day is very crucial. In fact, without that order
1 year
also,
have gone. 1
Today
year.
is Friday, Saturday, Sunday.
There was
Monday, your
no
lordship.
Lordship, my humble submission is very clear. It has fallen from Lordship's mouth also. They are
Want to, but then the objection.
the
is that we have not
objection,
received copies.
objection, whether that objection is tenable or not tenable.
No, whether if the copies are not served, then we have to give them
No,
a
look,
limited
I, in fact, in those cases where the copies were served, in that case, Lordship may clarify. But then I'll give that numbers. 3 cases we have served. They are the same councils.
So the same.
They are
thing,
the same councils.
whatever-
Lordship will kindly hear me for a
whatever
moment.
clarification you want.
No, Lordship, my humble submission, if
clarification
only the condition is that they have not received copies, and that is the sole ground of deferring this matter for that clarification till Monday, my submission is that the same councils in 3 cases, same petitions they have received.
No, we'll have it on Monday.
My
The
lord.
clarification.
In the course of the day, we may be served with a copy.
Whatever.
Yes.
Only for the clarification, because technically it doesn't require a clarification. I'm sorry, the objection coming from the other side, I don't know why, but whatever it may be, that clarification we'll consider on Monday.
My lord.
We'll take it up as a first item if you want.
Lordship.
My lord.
my lord, have we taken a position?
Writ petition. You see, we are listing the writ petitions on Monday.
Everything on Monday?
Only
And
that order
first
has to
item,
be
Lord.
now, earlier the hearing was fixed on 9th. So now that much will be changed to Monday. Everything will be.
Because
But
the main
you
issue,
wanted some time to file your objection, will you be able to file
Without,
your objection?
it's a point of law and
All right.
constitutional issues. Without that.
because
also.
in the main case, if it was filed, they have received everything.
We'll address our lordship.
And Monday as first item.
If it not
As
given
first
till now, my lord.
As first.
If they are diverting our application copies to the advocate's clerk, it is their fault, not our fault.
All right, Monday. Monday.
That first item, Lordship.
Yes, that's first item.
Highly obliged, Lordship.
But pending applications,
Hmm.
GSF, GSF
On Monday, on Monday. On Monday.
In 3 cases, we could not file the applications the other day because the councils were not present. In those cases, we are filing it and we'll give copies along with.
You make use of the emails and serve online copies, soft copies. Yes.
only take.
My lord, item number
Some applications have been filed online, we'll serve them and those also be listed.
Sorry?
But in other cases, applications, we have filed online.
You make a mention and mention memo and give it to the court. Yes.
My lord, actually, item 17 was a fresh case. When everybody joined in before my lord, I was thinking that I was possibly in wrong court.
Relating to the same issue.
Relating to the same issue.
We'll take it up on Monday.
Would it be possible, my lord, if your lordship issues the notice today?
Then
We'll
it doesn't
submit
come
today.
back on Monday. Then it will not come on Monday. It's your call.
But my case has to be addressed because as your lordship will take all the matters at one point of time separately.
We don't know. Let it come on Monday. We'll consider it. If notice is to be issued,
My
on
lord,
Monday, we'll issue notice.
My lord, my notice may be issued because only one thing, the interim is not in my favor. What Monday is in respect of the interim orders.
Don't make unreasonable prayers. You should have made a mention when the matters were being called up that item 17 is a similar matter.
Item
When
17
everything
came-
has been
Your
decided,
lordship, your
passed
lordship,
an order.
no, your lordship remembered when item 17 came.
Yes.
I was thinking that possibly I was in the wrong court. I started looking again because everybody joined in, my lord, including the
We'll take
advocate
it up
general.
on Monday.
Okay.
Yes.
Item 12 also, my lord, same, my lord.
Item
12.
12. Yes.
Actually, 28 to 31 are connected matters. I don't know where 32 and 33 are also tagged.
Okay. 28 to 31.
28 to 31. The simple section 11 application for appointment of an arbitrator, they have been repeatedly taking time and they've yet to file a reply. On the last
Yes.
occasion,
The
itself-
affidavit has been sent for vetting, my lord. We require just 1 week time, my lord. Was for signing and notary.
Where is this? Where is the arbitration agreement?
the clause your lordship will
Page
find in.
16. Page 16.
Yes. Page 16 is the arbitration clause. Agreement it's clause 18.
Hmm.
And in fact, the invocation clause disputes everything that we have said. And there's a clear violation of the termination agreement. And as per the law recently, I mean, not recently, the numerous judgments on section 11 confines the jurisdiction of this honorable court to a very limited scope, which is only to examine whether there is an arbitration agreement. The arbitration agreement is at clause 18 of the agreement of all these cases.
Where is your application under 21?
21. Page 34, your lordship.
Yes.
They have been, 34 is the reply. The invocation notice, your lordship, is at 32.
Yes. No response to that.
They have filed the response, which your lordship will find at page 34. There's no denial that the arbitration clause is not a part of the contract and binding on the parties. So once that is clear, 11(6)(a) is very clear that the parties have to be sent to arbitration. All other disputes between the parties will have to be thrashed out before the learned arbitrator.
Yes, when can you file it?
Next week, Malok. It has already been sent for
Give us a date.
Next week, Malok, fix any date, Malok. Friday or Thursday, Friday, Malok.
Last order also records their submission that it's.
All right, we'll have it on 8th of January.
8 Malok would be a difficult, Malok.
You wanted any date on next week?
9. Let's say on 9th.
What is the difference between 8 and 9?
Malok.
8th.
Malok.
Heard, Mr.
I am actually in some difficulty because I have to come.
Then?
Could it be, Your Lordship, in the first week of February, subject to convenience of the Honorable Court?
You were expressing urgency. All right. Heard learned counsel for the parties. The writ petition is this arbitration petition is directed against is filed under Section 11 of the Arbitration and Conciliation Act, praying for a direction to appoint an arbitrator to resolve the disputes arising between the parties, as the respondents have failed to agree upon the arbitrator proposed by the writ petitioner. Stop. The arbitration agreement, the clause for arbitration is reflected at clause 18 of the contract agreement dated 10th of January 2022, executed by and between the petitioner. Stop. The respondents have been permitted opportunity to file their response. However, the counsel appearing for the respondent prays for further time. Accordingly, as agreed to by the learned counsels, the parties list on.
Could it be 4th, Your Lordship, subject to convenience? 4th of February.
4th.
4th or 5th?
5th of February. 5th of February.
Lordship, may I just make one more prayer? There are two similar arbitration petitions which we had mentioned earlier, but somehow it has not got tagged. If I may give the petition numbers, they can also be tagged.
List these matters starting from 28, 29, 30,
31.
and 31.
Yes.
Along with arbitration petition number
32 of 2024 and 33 of 2024.
32 and 33 of 2020.
Much obliged. Deeply obliged.
Huh? It pulled open.
May I please, Your Lordship? Lordship, we had filed an application under Section 11(5) of the Arbitration Act for appointment of arbitrator. Lordship, item number 32 and 33 are similar matters. Lordship, time were granted to the respondents to file their affidavit. Till now, we haven't received any affidavit.
Malok, we have received instruction, Malok. Mr. Gupta is in legs in court number 9, Malok. Mr. Gupta, Malok. CGC appearing for the matter, Malok. We have received instruction the matter, Malok.
Lordship, last opportunity may be.
When do you want to file it? If you have received.
We'll file it, Malok. We'll file it.
When? Give us a time. Give us a specific.
10 days, Malok.
All right. List at the request made by the council appearing for the respondent, list this matter again on 5th of February.
Malok.
By which date the respondents may file their objections, if any. Mr.
C. Agarwal.
C. Agarwal appears for the writ petition. Yes.
Lordship, item number 32 and 33 are similar matters.
32, 33. Same orders.
Much obliged.
Much obliged.
Wait, please, just a minute. Because I'm led by Mr. B.K. Mahajan in this matter only. In fact, my lord, in a similar application, my lord has passed an order, my lord. So can it come up on 6, my lord, to bring for a similar order?
All right, 6.
Deeply
Much
obliged.
The request of learned counsel for the petition matter be. Let it not be on 6 because 6 we have already fixed a series of matters.
On 7 in that case.
Let it be on 8th.
Yeah,
8th.
much obliged.
8th.
Deeply obliged.
Yes.
May please. I'll just first tell what was the problem. The petitioner, he bought a plot of land for, by registered sale deed with the NOC from the collector. Then after purchasing the plot of land, he got the permission from the Municipal Development Corporation, Municipal Development Authority of Kasar District, Hailakandi, for construction of the wall. And after that, he got the permission and the trade license from the municipality for establishment of a showroom come repairing center for Bajaj scooter.
And also house.
And also house, that is a space. I will come page wise, my lord. Now what happened? Suddenly, when this business is running with 22 persons, your lordship will find the impugned order at page 38. I bought in part 1 at the behest of the local MP. How it is, why I am saying this statement, I will come to this, my lord. In pursuance of a direction, has your lordship got it? In pursuance of a direction while later dated so and so, you are hereby asked to vacate now they are saying government khas land, which has been under your possession at the Moza Gangadhar Thumkumar part 4. Page 13, your lordship will kindly see. My sale deed has been registered at page 13 at part 1. Thumkar is part 1, part 2, page 13, paragraph 15.
Yes.
And also page 15. Now your lordship will kindly see the next. What is this letter about? The MP, the local MP had some objections regarding my business because he has some other favorite business because mine is Honda. Honda scooter. So now he lost the complaint. At the last sentence, your lordship will see the MP has your lordship.
Yes.
Now your lordship will kindly now go by the. I will take your lordship to page 5, para 3, page 5.
Of the writ petition.
Of the writ petition.
Yes.
Para 3, I procured 2 pieces of adjoining lands as your lordship got it.
Yes.
Here the kotha, dag number, everything is there. Now your lordship, I will take your lordship to page number
28.
Page number 28. After purchase of the land, sale deed is also at page 27, page 28.
28, yes.
My holding number was also changed. Now that I got the permission of the sale deed, your lordship will kindly look at page number 23 of the sale deed. Because any sale permission has to be taken from the collector first. Sale permission is also mentioned. At the bottom, my lord, there is a number, has your lordship.
Yes.
I got the sale permission and the sale deed was registered. Then my holding number was changed at page 28. Then at page 29, I had to get a boundary wall construction permission from the municipal board. Has your lordship. Page number 29.
Yes.
Page number 30, the RCC go down. Page number RCC ground floor for the purpose of go down this showroom, my lord. Municipal board gave me a permission. Has your lordship.
All right. Let us issue a notice here.
But tomorrow.
Are you posted with any instructions?
I am for 2, 3, and 4.
So
Okay, sir.
2, 3, and 4.
4.
Who is 2, 3, and 4?
District Commissioner and Settlement Officer.
So you have to get your instructions. Because
Municipal board have to.
no. Notice is issued by the assistant settlement officer. Circle officer.
Yes,
He is the same person. No?
Page number 38.
Same.
Yes, 38. Page 38 is
My
issued by
same person.
circle officer, settlement officer. You have to obtain instructions here. heard Mr. K.P. Pathak, learned senior counsel, assisted by Chisti, learned counsels for the petitioner, and Mr. Mazumdar, R. Mazumdar. The writ petition is directed against the order, against the notice dated TF 20 December 2024 issued by the Circle Officer and Assistant Settlement Officer Hailakandi, putting the petitioner to notice that they have to vacate the government khas land, that the petitioner is required to vacate the government khas land under his possession at Moza, Gangpar, Dhumkar, Part 4 in the district of Hailakandi. Stop. A learned counsel for the petitioner submits that the petitioner you had purchased the land.
Yes.
I purchased the land in, that is belongs to part, Bhumkar, part 1.
May notice in notice, my lord, Gangapur Dhumkar Part 4.
I bought the land in part 1.
Notice, my lord, he occupied the government castle as per notice, my lord. But then
In annexure 30, Lord, say. Annexure 4, page number
address is
30.
different, my lord.
Address is different.
Let them destroy anything they find in part 4. If they think
Yes,
that I have something in part
Learned counsel for the petitioner submits that he had purchased a plot of land covered by tag number.
Tag number, my lord, that is at page number 13. Paragraph 5. Tag number 81 under bracket part P and 82 under second RS patta number.
Tag number 81 within bracket P and 82 within bracket P
Under
second RS patta
number
35 of Moza, Gangpar, Dhumkar, Part 1.
Part 1.
He has, after purchasing the said land, he has constructed a business commercial structure
and boundary wall.
After taking due permission from the concerned authorities. Stop. You have no land in Part 4.
I have nothing. It is the government. If they want to destroy anything, let them destroy anything in part 4.
Learned Senior Counsel submits that this notice is directed against the writ petitioner by referring to government khas land stated to be under his possession at Moza, Gangpar, Dhumkar, Part 4.
Roman 4.
Roman 4. Stop. However, he has no possession of any such land as reflected in the notice. Stop. He therefore suspects that this notice will be used to deprive him and dispossess him from the legally owned plot of land covered under tag number 81 and 82 within bracket P under so-and-so patta, Moza, Gangpar, Dhumkar, Part Roman 1. Stop. Being aggrieved, he has approached this court. You did not file any application before the DC.
My lord.
You did not file any application, appeal before the DC.
We went to the DC. Their DC did not receive, refused to receive because the MP wrote a letter. Next page, my lord.
Yes.
It is an MP's direction.
Where is that?
Your page number 39, last paragraph.
The learned senior counsel submits that the deputy commissioner Hailakandi was that the petitioner had approached the deputy commissioner Hailakandi ventilating his grievances, but the same were not redressed, and his application was not accepted in view of the fact that this impugned notice dated 20/12/2024 issued by the circle officer and assistant settlement officer was issued at the instance of the MP Karimganj What is HPC?
Hailakandi Parliamentary Constituency.
Hailakandi Parliamentary Constituency. Stop. Being aggrieved, he has approached district court, praying for appropriate direction or order. Better. MS PR Monto appears for respondent number 1. MS S. Purva appears for respondents 2, 3, and 4.
3 and 4.
5.
5 municipality board, we are not appearing for municipality.
Stop. Learned councils representing the respondents 1, 2, 3, and 4 submits that they would like to complete their instructions in the matter. And however, prima facie, the notice impugned in the present writ petition appears to be directed against the plot of land stated to be under possession of the writ petitioner at Moza Gongapar, Dhumkar, Part Roman 4, and not the plot of land under possession of the writ petitioner at under Moza Gangpar, Dhumkar, Part Roman 1. Therefore,
Where from I am carrying on the Hailakandi Motors, that showroom name is Hailakandi Motors.
SKD Motors.
HKD Motors.
Therefore, the grievance of the petitioner, therefore, in respect of the grievance of the petitioner, the councils appearing for the respondents pray for some time to complete their instructions in the matter. Having heard learned counsels of the parties, issue notice returnable 4 weeks. Since respondents 1, 2, 3, 4 are represented, notices are waived. Extra copies be furnished within a period of 1 week from today. Steps on respondent 5 by registered post ID, as well as usual course on respondent number 5. Stop. Meanwhile, till the next returnable date, the respondents will not proceed to dispossess the petitioner from the land stated to be legally under possession, covered by DAG number 81P and 82P under RS. What is that?
If petitioner occupying any government land, then he may be.
Not any government land. It has to be in that particular area where the notice is issued.
Yes. If
Under second patta, under second RS patta number 35 of Moza Gangpar Dhumkar Part 1, from where the petitioner
is carrying on
thinks
business.
to be carrying on his business under the name and
Under the name and style of
SKD Honda.
HKD Honda
Honda.
Service.
Showroom.
Showroom actually.
HKD Honda within quotes.
Scooter showroom.
Comma, two-wheeler showroom. Yeah. Stop. That's all. We are saying that in view of in terms of this notice, you shall not be dispossessed from that property. You say you have no land over.
If they want to dispose of anything,
if he is occupying in the land in this.
You vacate, we are not staying it.
Yes.
We are only saying that by virtue of this notice, we will not dispossess him from that particular land.
that is the only
List.
Till returnable date, my lord.
Yes, till return. No. What is the point in saying it?
No, my lord.
We are saying that till returnable date, on this particular notice, you shall not be vacated from this.
Yes. That is
Part 1.
My lord.
You say that you have no land under.
My instructions from the photograph, the bulldozers, they gave the note. I'm taking a loss 30 seconds time. They gave the notice moment the High Court was holiday started. 15 days notice, and they yesterday have brought the bulldozers in front of my thing because some other competing business companies are with the member of parliament, and he says he wants to dispose me of.
Next year, 27 November.
27 November.
Is the letter of the entry.
That is the entry.
No, it's not letter of the MP. The letter to circle officer from the department.
That is the letter on the basis of which circle officer has acted.
We'll have it on 7th of February.
7th of February. My lord.
Till the next week.
I'm highly obliged, my lord, for giving this opportunity. Otherwise, your lordship was notified to be.
No, there was some confusion. Actually, it was not meant